I came to build a business around contracts almost completely by chance or luck. It all started about 36 years ago. I found an entry-level contracts job coming out of the Marines, and I just happened to have a knack for it. So I spent my entire career, which, as I mentioned, is 36 years now, working in contracts in various industries and representing both the client and the service provider side of it. So I'm very familiar with both aspects of it. And then combine that with the fact that I've been a musician all my life and a producer for the past 15 years. And the fact that I'm also a partner in a small nonprofit record label called Boneyard Records. And I have the expertise of contracts with the understanding of the nuances necessary to navigate successfully music industry contracts. And in the context of the Boneyard Record artists, one thing that I understood very early on, one of their biggest needs was assistance in how to navigate contracts. They needed advice, etc. So this led me to start a music specialized contract services company designed for indie artists, which much more favorable rates and terms than the typical law firm offers artists in general. The key terms a manager or artist should be looking out for in a sync or licensing deal are these. At the highest level, I would say there are five things to really look out for, which are what are the fees, what is the territory, what is the duration, what is the media, and of course, exclusivity. At a more granular level, I would say that contract needs to clearly define the parties, right? Who's the licensor, who's the licensee, details of the work being licensed, title, composer, all the codes associated with it, etc. And when I say codes, I mean like ISRC codes and those kinds of things necessary for tracking royalties. The specific master recording being licensed, and I would warn that a risk in this, improperly defining this as an example, you could have an album name that's the same as a song name. And if you don't properly define it, you may be signing up for the entire album rather than the song that you meant to do. So just be very specific about that. The specifics of the audiovisual project for which the license work will be used and how it will be used, such as background, theme, credits, etc. The term, of course, the duration of the license, the territory where the license is to be used, whether there's exclusivity, which again, I'm against, if at all possible, any options that may be unilaterally executed solely by the licensee. And I think it's worth expanding on this a little bit. Many contracts have options that can be exercised. An option is something that goes beyond what the basic agreement is. So it's an additional right or obligation. And very typically, what I'd like to do is to make sure that they can be bilaterally executed, meaning that both parties need to agree to exercise that option. So try not to sign up for options that the other party can unilaterally exercise on their own. The other thing is who receives credit and how. I'll use myself as an example. If I'm working on something as a producer, I go by J.L. Espada. If I'm working on something as a songwriter, I use my full name, Jose L. Espada. So depending on what the context is, just make sure that you get credit the way you want to get credit. Any guarantees on representations, I would say, is very important. Indemnification responsibilities. I mean, we could talk all day about indemnification, and I won't because I'll bore you, but indemnification is one of the most complex provisions in contracts in general. And that's a typical provision that's written by lawyers for lawyers, where you have 6 or 8 lines of a running sentence and Lord knows who can follow it. So I'm not going to tell you what to look for essentially, but I will ask you to just be sure you understand what the indemnification is asking of you. And if you don't understand, consult with an attorney or contract expert to help you navigate it. Then there are treatment of samples used in the music. That's really important. People don't think about this. When you're doing a split sheet, as an example, if there are samples, you need to make sure that those samples are being credited to the right party. And if it's a license, great. If not, what royalties do they get for this? Those are really important things to sort out. Then, of course, again, termination rights is an important thing. And finally, performance rights. Aim for retaining the right to collect performance royalties through your PRO.